Hello and welcome back to Come Geek Some. If you are new to the channel, please like and subscribe for all future content. Sometimes when you look online and you see on Twitter and you just have to think, what is going on with this person? And what we're going to look at here now today is, if you remember a couple of days ago, we actually did a video regarding Monica and Ron Toye's lawyer solicitor, that they actually sent a letter to Judge Chupp. Well, 2 days later, they actually sent another one. And that's what we're going to look at today. So this is coming from Ejo Bear on Twitter. Thank you very much for putting this up there. And I have started following you now. And this is what they've had to say. A certain legal gardening tool is angry. Why doesn't he just simply make his motions? Which is very true, because he's done this letter and now he's just put something else out there, which is just like, well, why are you even doing this? There's no point. And we're going to have a little look at the letter now. So obviously we've got the normal, the judge, where he is and all that. Dear Judge Chupp, I write on behalf of Moncia Rial and Ron Toye to address plaintiff's recent notice of appeal of this court's October 4th, 2019 order, granting all defendants respective motions to dismiss the appeal. So with that then, it's actually good to see that Vic has actually filed now his appeal by the looks of things. And we still haven't seen that though. But obviously with this, with him saying, his recent notice of appeal, so he's done it. So I'm going to carry on. Because the appeal is legally improper, we will file a motion to dismiss as soon as the clerk issues a cause number. We suspect the Fort Worth Court of Appeals will quickly dismiss the appeal. See Hollis vs. ProPath Associates. So I assume that's like another court order that's gone through and someone else has tried something there. Which they say as well, order granting dismissal under the TCPA that does not resolve all claims is not subject to appeal as a final judgment or on an interlocutory basis. Pope Nixon, another one there, dismissing appeal for want of jurisdiction for lack of finality where trial court granted TCPA motion but resolved the issues of attorney's fees, costs and other expenses for future determination. As plaintiff acknowledges in his notice of appeal, he does not appeal a final judgment. Vic desires to appeal the order granting defendants motion to dismiss and all orders granting fees, costs, or sanctions thereafter. Emphasis added. Accordingly, at best, plaintiff attempts to appeal an interlocutory order in anticipation of potential arguments from plaintiff. No stay is in place in this matter because there is no appeal of a denial of a TCPA dismissal. Texas Civil Practice and Remedies Code addresses appeals from interlocutory orders as follows. And we're going to look at these now. So the first one says, a person may appeal from an interlocutory order of a district court, county court at law, statutory probate court, or county court that. Then we got another one. Denies a motion to dismiss filed under sections 27. An interlocutory appeal under subsection A3 and all this kind of stuff. Also stays all other proceedings in the trial court pending resolution of that appeal. Plaintiff's premature appeal meets none other criteria for a stay. So absent further direction from the court, we will comply with the order and appear for an evidentiary hearing on November 21st, 2019 at 10:30. So that's when we see that this is actually going to happen now, ladies and gentlemen. This is when they're going to start doing something. In the intervening period, in accordance with Texas Rule of Appellate Procedure 33, all these, defendants request the court issues orders on a few issues. First, given that plaintiff has tipped his hand as to appeal, we request that the court enter an order on defendants' omnibus objections to plaintiff's TCPA evidence, filed September 3rd, 2019. The objections: while we agree that the court properly disallowed the attachments to plaintiff's second amended petition in the event that the Fort Worth Court of Appeals were to consider such evidence, much of which is hopelessly defective, a ruling on the objections, even a blanket grant or denial, would preserve the issue for review and prevent a remand to consider those evidentiary issues. See someone else's whatever happened there. Reviewing hearsay and speculation objections overruled on the record. Second, we request that the court strike the second amended petition in its entirety, pursuant to Moncia Rial, Ronald Toye, and Jamie Markey's joint response cross-motion to strike. 1. Plaintiff's response to the TCPA motions to dismiss. 2. plaintiff's second amended petition, and 3, to deny plaintiff's motion for leave to file late responses to defendant's TCPA motions to dismiss due to technical issues, filed September 3rd, 2019. So we're starting to use all of them there, and it's like, well, they were late every single time in filing their actual court appeals themselves, but when they were doing it, they were taking a sweet time. And Vic was like, yeah, okay, why? He kind of allowed it. He was like, yeah, go on, let him do it, or whatever. But then, obviously, as soon as Toye messed up on one thing, and even though he filed it the same day, they jumped on him like a pack of wild dogs. So we'll carry on. Again, we agree that the court correctly noted in the order that it excluded the attachments to the second amended petition. However, allowing the plaintiff to effectively ambush the defendants with a late-filed pleading, even absent its attached evidence, furthers the plaintiff's improper strategy, without a clear exclusion of the petition as well as the evidence. Plaintiff will undoubtedly attempt to rely on the second amended petition on appeal. A ruling on the objection raised as to fitting of the second amended petition would also allow the Court of Appeals to determine if plaintiff's tactics are appropriate, and also avoid remand on this issue. It's kind of issue there. It's a little bit funny because Sean Lemoine, and he's literally just trying to be a douche. And the things he's saying, it's like, well, just need to file it. Just do whatever you need to do. Don't try and stretch out now with all these letters to the judge. It's almost like like when a teacher says something about someone and you're like, oh, I want to be the teacher's pet. That's what these look like, and this is what this sounds like now. It's really funny. And the final page, I'll make myself available should the court wish to address any of the foregoing issues. Regards, Sean Lemoine. Or counsel of record via ECF, whatever. Who cares? But yeah, so that's what we got by there, and that's exactly the thing that I look at, and I'm thinking, right, okay, you're a little bit out there at the moment, Sean, because the things you're saying and the things you want to do, it's a bit like, yeah, come on, just file your motions, just do what you need to do. He's put in his appeal, you should just go and do yours. That's what you need to do. But he's not going to do that, is he? And it's almost like he's just trying to just push this out as far as he can, and I don't understand why. Maybe he's trying to get more money, trying to spread it out, be a little bit longer than normal. So it'd be interesting to see how this goes on. If you are new to the channel, please like and subscribe, hit that notification bell for future updates, and I'll see all you wonderful people soon.